The Succession Amendment Bill 2021 of Uganda proposes that in the event that the deceased died without writing a will, this is how their estate will be divided. 75% of the estate will go directly to taking care of your immediate family or lineal descendants. 20% of that 75% will specifically cover education and maintenance of your children. Now, 20% will go directly to your legally married spouse, who is your partner in marriage. It has to be a legal marriage. And 1% will go to the heir, and lastly 4% will go to your dependents. My name is Dagaiv Joan, and this is the Ask Me About the Law channel, where we have free and honest conversations on the nexus of law, technology, trade, tech, finance in Uganda. We have new conversations on the Ask Me About the Law channel every week, so please subscribe so that you do not miss out on those notifications. Without further ado, let's dig into today's video. The Parliament of the Republic of Uganda has passed the Succession Amendment Bill 2021, meaning that it is now waiting for the President to either sign it into law or have it go back to Parliament to have it addressed. So in the event that the deceased passes on intestate, meaning that they did not write a will at the point when they passed away, this is how your property will be divided. The bill provides that in case the intestate is survived by a spouse, lineal descendants, a dependent relative, and a customary heir, this is how the property will be divided. 20% of your property will go straight to your spouse. Major takeaway is that your spouse that is factored into as per the Succession Amendment Bill is a spouse you acquired through a legal marriage. This therefore means that even if you have cohabited with your spouse for 20 years, you have children together, legally speaking, that is not a legally recognized marriage. Your marriage needs to have been conducted by a regulated institution that is licensed to conduct marriage, and the person that officiated said marriage has to be licensed by the laws of Uganda to conduct a marriage. 75% of the estate will go directly to taking care of your immediate family or lineal descendants. 20% of that 75% will specifically cover education and maintenance of your children. Now, 20% will go directly to your legally married spouse, who is your partner in marriage. It has to be a legal marriage, and 1% will go to the heir, and lastly 4% will go to your dependents. The Succession Amendment Bill 2021 proceeds to define this 20% as the Education and Maintenance and Welfare Trust Fund of minor children, meaning that not everyone qualifies to benefit from this trust fund. And let me explain what that means. It says that this trust fund is held in for the benefit of minor children, children who are above the ages of 18 but below the ages of 25 of age, if at the time of the death of the intestate these children were undertaking studies, they were not married, and they are children with disabilities who are above ages of 8 or ages of 18 years of age, if at the time of the death of the intestate these children were not married, were wholly dependent on the intestate for their livelihood. So this means these are the only people who are qualified to benefit from the 20% education and maintenance fund. All this will come into effect if the deceased at their death they did not write a will, but there are other exceptions that we'll discuss more in the next video. Event that the deceased is not survived by other dependents as provided for earlier on above, or a spouse, the Succession Amendment Bill 2021 designates that the beneficiaries that will take the largest percentage in this instant will be the lineal descendants who are their children. In the event that the deceased is survived by a spouse and only dependent relatives, no linear descendants, the Succession Amendment Bill 2021 provides for the following allocation of their estate. The spouse will get 50% of the deceased's estate, the dependent relatives will get 49% of the deceased's estate, and lastly, the customary heir will only get 1% of the estate. So in the event that the deceased does not have linear descendants or children, surviving relatives who are, in this particular instant, the spouse or dependent relatives, the allocation states that these individuals will get 100% of the estate because they are the only living relatives left and also living dependents on the deceased's estate. So, in the event that the intestate or the dead, the deceased does not have any of the following dependents or family relative, close family relatives available to take and benefit from his estate, the Succession Amendment Bill provides that their estate will be divided equally between the relatives next in kinship of the intestate. And it also provides that where the intestate leaves no person surviving him or her capable of taking care of the estate or fitting the description of being a spouse, a dependent relative, or a linear descendant, then all of their estate shall be managed by an administrator general as provided for by the Administrator General's Act. So, as Succession Amendment Bill proceeds to address things like the family home, or rather, for it refers to it as the principal residency, which is where the family of the deceased stays or has been staying for the major part, or what they would refer to as home. This is property that is specifically for the family, and as such, it will not be factored in when or included when the estate is being divided, because for it is property that is for the family. End of discussion. The family meaning the spouse or the children, and they are the only ones that will be benefiting from that. Therefore, if anyone that is not directly supposed to benefit from the division of the estate tries to evict or sell that property without getting permission from the family, or without having a court order that says that you stand a high chance of being arrested and sent to jail for violating the Succession Amendment Bill if it is passed into law. In the event that the surviving spouse or the deceased that died intestate decides to contract another marriage, the Succession Amendment Bill 2021 protects them and provides that they will still benefit and will enjoy the benefits that they were or are entitled to as per the Succession Amendment Bill, which is the 20%. However, the Succession Amendment Bill also proceeds to state that in the event that at the point or time of death of the deceased, if there was a form of separation, which can include, for instance, if one of the spouses was not defined as a member of the same household, then the Succession Amendment Bill states that they will not enjoy the benefits that they would have if they were or were still defined as a married spouse. So this would factor in, for instance, things like divorce. If you divorce the deceased prior to their death, then you are not entitled to benefit from that 20% that is designated for a spouse. The Succession Amendment Bill nullifies the definition of the word illegitimate and replaces it with the word child born out of wedlock. This means that when we were discussing the 20% trust allocation for education and maintenance of children, it also factors in any of the spouse's kids, any of the kids to either spouse who are born outside of wedlock. So instead of calling them illegitimate, now they are referred to as children born out of wedlock, and they are also entitled to benefit from the 20% education and maintenance trust fund. This also covers children that are adopted. So in the event that you dispose of your property via your will, and say disposal, you do not factor in how for instance, your children will be taken care of, your spouse, the Succession Amendment Bill provides that the courts of law, upon application or upon request, may intervene and have your estate divided as per the demarcations I discussed above, to factor in and take care of your spouse, your children, and your dependents and other linear descendants. So the essence is that the courts of law ought to be requested to intervene to properly award and make sure that your family and your dependents are taken care of. In summary, what this means is, do not think that in case you have written a will and you leave out your family or your dependents, that your estate is safe. Yes, the courts can be petitioned and they will address the matter as the Succession Amendment Bill requires. Now let's talk about gifts given to another person in contemplation of death. Now, the Succession Amendment Bill 2021 provides that one can receive a gift. However, the donor has within 6 months of which they can claim said gift back from you who they've given the gift. And in the event that when they do not actually die and they manage to push through, then that gift in contemplation of death will no longer suffice, and they have the grounds to claim it from you. The bill also proceeds to state that in the event that the deceased died with debt, the debt shall not extend to affect the residential or principal property unless the spouse consented to have or let's say to get credit and used the residential property as security. So as far as the bill proposes is that those debts will be null and void to the extent of affecting the family residential property. So that is all I had for you today on this channel. Today was all about just addressing a few things here and there that have been addressed on the Ask Me About the Law channels, and also from social media, the inquiries all of you were suggesting I address. If you have any more questions regarding this bill, please leave them in the comment section. If you enjoyed this video, please give it a thumbs up and share it with a friend. And also subscribe to the Ask Me About the Law social media handles. Until next week's video, which will be available on Sunday. Subscribe so that you do not miss out on that notification. I remain your host, Nagayo Joanne, and I will see you in the next video where we'll be talking about the landlord and tenant bill.